Hello, what's up, everyone? So, today we're gonna be looking at the subject of equity and trust. And for this video, we're gonna be looking at two topics, which are certainty as well as resulting. So, without further ado, let's go. First, certainties. What is a certainty? So, basically, for a trust to be valid, there must be three certainties. That means there must exist three things that is to be sure in that valid trust. This is outlined in the case of Knight against Knight, where the judge, which was Lord Langdale, laid out the three types of certainties, which are intention, subject matter, as well as object. Of course, judge language will be much more flowery compared to uh, that means what the judge stated in the case of Night Against Night isn't intention, subject matter, as well as object. Dia macam flowery lagi lah, but we can extract that the three types of certainties: intention, subject matter, as well as object. Okay, firstly intention. So, intention refers to the settlor or the trustee's intention to create a trust and not a mere gift. So, when a trustee, who is the person who has the property, wants to create a trust, there must be an intention behind it. So, in the case of ESPL Sdn Berhad against Radio and General Engineering Sdn Berhad, this intention can be created by any language that is sufficiently clear. That means you don't need to use formal language or anything. You just need to have a sufficiently clear and unequivocal intention. Macam tu. So, what if the language is unclear? Then the court will look at the construction of the intention in itself, and mere expression is not enough. So, from this construction test, they will determine whether or not there exists an intention or only a mere expression. So in the case of one Naima against one Muhammad Nawawi, okay, by the way, for this subject specifically, I have included a case counter here. So for all of these two topics, there are 33 cases, and I guess it will only increase lah as we cover other topics. Okay, by the way, in the case of one Naima against one Muhammad Nawawi, only any words that can confer intention is sufficient, even if it is informal. And in the case of Kwa Eng Hock against Ang Hui Kiam, precatory words are not trust. Okay, precatory words are words that confer wishes or uh, expression lah. Maksudnya, uh, jap, to illustrate, we'll look at other case laws lah nanti. Okay. In the case of Yap Joyce against T. Molly, there must be sufficiently expressive words and must also create mandatory and legal obligation. So the words used must be sufficiently expressive as well as creating mandatory and legal obligation. Okay. This is an example of precatory wording. So in the case of Lum against Adams, the trust included the words at her disposal in any way she thinks fit. This is precatory because it does not confer any obligation. See, at her disposal. Okay, at her disposal means it is for her to use in any way she thinks fit. That doesn't confer any obligation at all, because any way she thinks fit is basically up to her discretion, not up to the trustee's discretion. That is what precatory is. Okay, this principle is reaffirmed in the case of Ree Adams and Kensington. Okay, in the case of Ree Hamilton pula, construction varies from judge to judge. Okay, this is basically to say that while when Judge A says there is no trust, Judge B can say there is trust. This is what Ree Hamilton states. The construction or how the court interprets what a trust is varies from judge to judge. Contoh. Okay, next, the case of Kominsky against Boring Hanbury. Precatory words were used in this case. However, there is a way for precatory words to also constitute a valid trust by way of reading the whole document as a whole. Because in this case, precatory words were used in the trust, in the will. However, when the court read the whole entire document as a whole, the precatory words which were just now invalid became a valid trust because of it. Okay, macam tu. Next, in Dato' M. Cavius against Si Hong Chen and others. Precatory words however clumsy, when read in a whole, as in the whole document is read, can confer obligation. That is basically what Kaminsky is talking about lah, but it is further specified in this case, Dr. M. KVS. Okay. About surrounding and conduct and surrounding circumstances. What if there was no express wording or no written will in the trust itself? The court will look at conduct and surrounding circumstances lah. Okay. In the case of Paul against Constance, okay, in this case, a man left his wife, remarried, and he put some of his money into an account, stating to his new wife, this money is as much as mine as it is yours. That means the money is shared between them. The man later died, and the original wife wanted to claim the money for herself instead of the new wife. So the new wife argued that since the man stated that the money is as much as it is his, as much his as it is hers, hers to referring to the new wife. The new wife is now the owner of the new of the money lah, and the court reaffirmed that. The court agreed with the argument. That is basically it. Okay. However, what if the intention of a trustee is to create a sham or mere facade? We can see that in the case of Midland Bank against Wyatt, the trustee relied on an unnotified trust. Basically, he put his house or his property onto a trust without notifying Ajak. The person put his land and property onto trust with the beneficiaries being his wife and children. However, they were not notified of this trust. Later, when the person's business went insolvent, he relied on the property held in trust to escape his creditors. So the court held that the formation of the trust itself was a mere sham and facade. Okay. Later, another case, which is in the case of Ho Min Hao against Ho Yi Chin, the court states that a lawful trust for an unlawful purpose is void. Contoh. Okay. So what is the effect of an invalid intention? Basically, there is no trust and it becomes a mere gift. It does not become a trust. Okay. So that is for certainty of intention. Next, certainty of subject matter. Okay, subject matter refers to the thing that is being um, given onto the beneficiary, which is the property lah. But property, this is not property per se. It is also like other things like cars or laptops, money. It doesn't really property here does not really mean land per se. Okay, okay. For a subject matter to be certain, there must be um, three requirements. Firstly, it is clearly defined. Secondly, it is identifiable as well as ascertainable. And lastly, it is sufficiently certain. So in the case of Xiao Lin against Harta Lega Holdings, there must have a clear evidence to show the existence of a subject matter for a valid trust to be constituted. Okay, basically, we're going on a little tangent here, which is semantic certainty. Semantic certainty refers to terms used in the trust that have to be clear and free from multiple interpretations. That means semantic certainty talks about um, the certainty of the object is certainty of the property being held, and there cannot be any other interpretations. For example, uh, I put this power bank onto trust. So I put this power bank and I say this in my will I state I contoh saya letakkan an electronic gadget for someone. The electronic gadget can be interpreted in multiple ways. Therefore, I have to specify what electronic gadget I was talking about. Contoh. That is semantic certainty. In the case of Recops Will Trust, so in this case, the trustee wanted to put on trust blue chips stock. However, the court held that there was no meaning to what a blue chip is. So the trust was invalid macam tu. Next, Sprang against Bernard. This is lebih kurang je macam records whereby it states that what is left of the stock. What is left of the stock is insufficiently identified, and this is later reaffirmed in the case of Palmer against Siemens, which is basically the same thing but for estates. So how can we identify the property? This and this as well as well as the bulk test, which I forgot to write down, so I'm sorry for that, is the three tests to identify or to see lah how certain a subject matter is. Okay, firstly, the first test is identification of property. There are four categories to a subject matter, which are tangible, intangible, fungible, as well as infungible. So tangible property is a physical property, like everything in this room, a chair, maybe this whiteboard, a house, a car, anything that is physical. However, for intangible, it refers to abstract properties which can refer to stocks, shares, something that may be related to crypto, I don't know. Okay. Okay, next, fungible. Fungible properties are interchangeable and similar in category. That is to say that, contohnya, shares are basically more or less the same as stocks. So they are interchangeable in terms of category. So that is what fungible is. However, infungible is a property that belongs in different characters and belong on their own lah macam tu. Contoh, I cannot mix a car with a property, a land piece with, contoh, a TV, macam tu, because they're in different categories. Usually what I see is a tangible property is also infungible, and an intangible property is a fungible property. I'm not sure if it's the general rule, it's just something that I noticed lah macam tu. Okay, next, segregation test. So some subject matter that is being put onto trust must be segregated. That means that it must be differentiated or put differently in a different spot with the other things that is in the same category but is not put on trust. Okay, property held on trust must be segregated, and if there is no segregation, there is no valid trust, and the trust is void lah. Okay, in the case of Hunter against Moss, in the plaintiff is, I can't remember, 50 baca je, 50 shares were given without evaluating, but however they were valid because they were fungible trust. Okay, so basically in this case, 50 shares ni adalah shares lah, macam stocks. They were given on a trust, however they were never evaluated based on their value. Maksudnya diorang tak tahu satu share tu bersamaan dengan berapa pound or berapa dollar. And however, because the trust subject matter falls within the category of a fungible trust, the court held that okay, it's okay, because I don't know actually why. However, it is later distinguished in the case of Real London Wine Co. Limited, where, okay, in this case, I think this is the easier case to follow, where there were few bottles of wine that were held on trust for customers. However, they were not put in different cellars. They were not put in different rooms lah, so to say. So maksudnya, okay, contoh dalam banyak-banyak marker ni, ada satu ni put on trust, but this marker is mixed with the other markers yang tak put on trust. That is what happened in the case of Real London Wine Co. Limited, and the court held that because this one wine bottle, in this case this one marker pen, was not segregated, nor was not put in different locations, it did not constitute a valid trust because there must be segregation. The court held that to create a valid trust, we must be able to ascertain who the beneficiary is and what property is attached to that beneficiary. Macam tu. If we put it in a mixed manner like this, how can we ascertain which one is tied to who? Okay. However, this is later as well distinguished in the case of Re Kayford. Okay. I guess it is not distinguished. Okay, so these three refer to betul lah. Dua ni valid. This one is invalid. My bad. Okay. So we actually have a section for bulk test here, but I didn't write it down. I'm not sure why, so I'm sorry for that. So we're just gonna move on to certainty of object. Okay. So certainty of object refers to who the beneficiary is. So we have three certainties right now. First is referring to the intention, who is the trustee. Intention of the trustee to create a valid trust. Secondly, what the trustee wants to transfer, what the trustee wants to transfer in terms of property. So kita ada the first party, the thing being transferred. Now we're going to look at the second party, the receiver lah, semester, who the beneficiary is. Okay, in the case of Bauman against secular society, valid trust must benefit individuals. That means there must be an ascertainable and identifiable group of persons for a valid trust to be constituted. Okay, in the case of Morris against Bishop of Durham, okay, we see that in the writing of the will itself, it included the wording as the trustee, and however, there was no specification of who the trustee, who the beneficiary is. So the court held that there was no beneficiary, hence the trust was void. Okay, so for certainty of object, there are two different categories that carry out two different requirements lah, so to say. We have fixed trust as well as discretionary trust. So, firstly, fixed trust. Fixed trust is something that is already being written down lah semester. So, in the cases of fixed trust, there must be a specified beneficiary included in the list of beneficiaries. Maksudnya there must be a specific name or specific class of people to be included in the list of beneficiaries. And the trustee must be able to fix this full list. Fix ni maksudnya create lah a full list of beneficiaries. However, if a beneficiary member is a member of a class, that class of persons must be identified clearly, as in the case of IRC against Broadway Cottage Trust. Okay, however, let's say that in contohnya 100 beneficiaries, maybe 5 of them are not traceable, cannot be identified. So what does the court do? The court held that the court states that a trust does not become void simply because a beneficiary is missing, because they follow the Benjamin order, which is basically to uh, consider the missing beneficiaries as dead, and they will distribute the property or the subject matter among the surviving or the identifiable other beneficiaries. Macam tu. Okay, that is for fixed trust. However, for discretionary trust, since discretionary trust is at the discretion of the trustee also has the power to choose who he wants to transfer or to move his property to. We can see here, it is at the discretion of the trustee to choose who his beneficiaries are, and it is sufficient to only determine who the claimant is in description with certainty. Maksudnya, you don't need to identify, okay, tadi fixed trust, you have to identify them contoh by name. So every single person has to be identified by name. But it is not applicable to discretionary trust. You just have to identify who belongs to which category and if that category is within the beneficiary class. Macam tu. We can see that in the case of McPhail against Dalton, the beneficiary now has the burden to prove he is in the class of beneficiaries. And in the case of Bedden's will trust, a relative is sufficiently identifiable. So this is basically a um, very niche set of conditions lah, which led the court to say that a relative is sufficiently identifiable. Because if I'm not mistaken, in this case, the trust included the wording of relative and all that. Lepas tu tiba the friends of the trustee pula nak claim the acquaintances of the trustee pula nak claim this trust, stating that they belong in the term of relative, which is in the beneficiary. So the court held that a relative is someone who you contact frequently, you talk frequently, and not it is not transactional. However, acquaintances in most cases are. So the acquaintances were not included in the beneficiary list. So this principle was later affirmed in the case of Re Barlow's will trust. Okay, next. Aduh, I'll go here. Okay, so what are the grounds for uncertainty of an object? Uh, how can a list of beneficiaries be uncertain lah macam tu? We have three ways. Firstly is a conceptual uncertainty. This is basically referring to the wording of the will itself, which is why I wrote here linguistically uncertain. So in the case of Spartak against Domet, which can illustrate what conceptual uncertainty is, the will included the wording of for my good customers. We cannot ascertain who a good customer is. We cannot know who good customers are and who bad customers are. That is why it is linguistically uncertain and it falls under conceptual uncertainty. Secondly, evidentiary uncertainty. So evidentiary uncertainty is basically all of this: fixed trust and discretionary trust. How can we prove that someone is under a class of beneficiaries? That is why I wrote here, it is more lenient on discretionary, because for discretionary trust, you don't need to identify specifically pun who belongs to where. You just need to identify the class. However, for fixed trust, you need to identify the person in the list of beneficiaries. Okay, and lastly, administrative unworkability, and this refers to how large a beneficiary class is. Because if a beneficiary class is too big or too broad, then the trust at the beneficiary list itself becomes uncertain. In the case of R against District Auditors West Yorkshire, this case ada 2.5 million beneficiaries. So how can we distribute the trust to 2.5 million, because the class is too large. That's why it is uncertain. Okay, what is the effect of an uncertain object? It is void, and if the property had been transferred, it becomes a resulting trust. That is why I included the topic of resulting trust here, because to understand resulting trust, you need to understand certainty of object, because once an object is uncertain, if the property had been transferred, it becomes resulting trust. So what is resulting trust? Resulting trust is an equitable reversion. Equitable reversion basically means, where's my marker? Okay, reversion means if a property had been transferred already from A to B, it's just a reversion of that from B to A. Kau pulang balik property yang kau dapat. Macam tu. It can arise from two things. Firstly, a settlor creating a failed express trust, which is basically an uncertain object, or the property is not fully disposed. And hence, the court presumes that since there was an uncertain, there was an occurrence of one of these two events, the settlor or the trustee wants his property back. So, because of an uncertain trust or a failed trust from A that's been created by A, if the property has been transferred to B, the court presumes that A actually wants the property back. Because because of an uncertainty, um, there is a gap in ownership. And we know that the Latin maxim, the equity maxim, equity abhors to a vacuum because it works to fill in the gaps, which is why the property moves back to the trustee. We can see that in the case of Re-Abbott Fund, the remaining monies were declared in resulting trust because, if I'm not mistaken, this was the case concerning a sum of money that was yang dikumpulkan untuk education of a particular person's children. And once the children had graduated, the money that is left over is declared in resulting trust, meaning to say it is given back to the persons who gave the money to them. Okay, we can see that in the case of Re-Andrews Trust, there is basically the same thing, but for children of a Jerusalem bishop. Okay, macam tu. So, resulting trust plays with the presumption of advancement, which states that contributors who helped obtain something without given a legal title is presumed to have a beneficial interest. Okay. In the case of Hodgson against Marx, in this case, Hodgson has a cottage and he gave it, if I'm not mistaken, he or she, I can remember, I think it was a she. She gave it to her niece, cottage, to niece. Okay, so this niece further sold the cottage to the Marx, who was a family. Okay, then because Hodgson was the one who gave the cottage to her niece, she had a beneficial interest. So once the Marks bought the property, they moved to the cottage. And when they went to the cottage, Miss Hodgson was still living there, so to say. So the court held that the trust was the the court held that the cottage was held in resulting trust, That is to say, the cottage was moved back to Miss Hodgson. Macam tu. If I'm mistaken, that was the gist of the facts of the case lah. Macam tu. So basically, Hodgson had a beneficial interest, so she got the cottage back. However, we can rebut the presumption of advancement by way of looking at the circumstances. This is reaffirmed in the case of Re Vandervelde's Trust number 2 as well as Women Against Gurney. Macam tu. Okay? That is it. Let's see.